Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Nick Esterbauer.
And I'm Darien Murray.
Welcome to Hull on Estates. You are listening to episode number 650. Today, we'd like to discuss a recent family law decision in O'Connor and O'Connor. It's a 2022 decision, ONSC 3482, and it involves an inheritance, a joint bank account, and a trip to Disney World. This decision came to our attention after reading a post on Russell Alexander's blog website. Now, before we get into the actual law here, I've recently discovered that my colleague Darien has some experience with Disney World herself, and I was hoping she might be willing to share a little bit about that with us before we get into the case.
Yeah, I actually used to work at Disney World in Orlando, Florida. Nothing as exciting as being friends with a character or anything. I was serving in a restaurant in a steakhouse there in the Canada Pavilion, so it was an excellent experience.
But not one of the princesses.
Unfortunately, I wish, but to be friends with a princess, you have to be American.
Still a magical place to be, I'm sure.
Oh, the most magical.
So turning to the law, this decision, the O'Connor decision, deals with the issue of an inheritance that was received by the wife, and it was used in a way that gave rise to an argument by her husband that he had an interest in it as part of the equalization of their net family property. Some of us might remember from law school the basic principles of family law equalizations, and that assets that are received by a spouse from an inheritance are normally excluded from net family property. So that means that they remain that spouse's asset without any corresponding equalization rights of the other spouse. And that's dealt with under the Family Law Act, where we go to, I know as an estate lawyer, if we're talking about family law issues, I'll take a look at the Family Law Act, or I'll ask a family lawyer who has some more experience with that. So here we had a situation where it was argued that because the way an inheritance was used, it shouldn't be excluded from NFP and equalization calculations. Darien, do you mind taking us through some of the facts here?
Yeah. So in this case, it was a couple that had been married for 29 years and they were getting a divorce. There were a couple issues, like Nick mentioned, that they needed to have resolved before a court. So they were struggling with the equalization payment, spousal support, and the payment of post-secondary expenses. So the main item at issue for our interest in this podcast was, as Nick mentioned, the inheritance. So when the wife's aunt passed away, she left her about $26,000 US. So the wife opened up an RBC account specifically for those funds. She put those funds in the account, and that was the only money that went in there. The wife's father then recommended that the wife put her husband on the account as well for succession planning purposes, so that if the wife passed away, the husband would then gain control of the account and could manage it after her passing. So the wife did that. The husband had no control of the account. The wife managed that account as well as all of the family's finances. The husband didn't take funds out of the account, didn't add funds into it, neither did the wife. The only thing this account was used for was the family trip to Disney World.
And because of that, the husband was arguing, oh, this is an asset I have an interest in as well. It's not an excluded asset. It's not just an inheritance, because you've been using it for the purposes of a family trip and perhaps other family expenses as well.
Yeah, the husband said that since it was used for that family trip to Disney, the assets had effectively been commingled with the family assets, so it was no longer considered an exclusion for the net family property calculation.
Darien, before we move into the outcome of this decision and what it might tell us about, how we might want to work with assets like this for estate planning purposes, there is a reference in the decision to the statutory presumption of resulting trust and how jointly held assets between spouses may be considered. And of course, this is different in a way from the presumption of resulting trust that we deal with in the estate law context. So in estate law, the presumption that we're more familiar with, or the application of the presumption we're more familiar with, is of course like the classic case we see in Pecor and Pecor, Supreme Court of Canada's decision, in which the law was clearly set out. And in that case, there was an adult child, there was a bank account held by their parent. The adult child was added as a joint account holder. And after the parent died, of course, the adult child received that asset by right of survivorship and said, "This is my asset." But no, the court ruled and confirmed that a presumption of resulting trust in favor of the estate applies. So it was an asset of the estate instead of an asset of that child. And of course, it's a rebuttable presumption too by an intention, evidence of an intention to gift. And that's something we see on our files, either allegations that the presumption applies or that there's evidence that rebuts the presumption. So going back to this O'Connor decision, Darien, do you mind telling us what the judge decided in the end?
Yeah, so the judge said that there was a presumption of resulting trust in this situation, that the husband and wife were holding the funds in that bank account in trust for the wife solely. The husband could rebut that presumption on a balance of probabilities if he could prove that the wife had an intention to gift him half the assets in that account. So like I mentioned before, the wife had been in control of that account. The husband didn't deposit or withdraw any funds, and the wife really didn't either, other than that one trip to Disney. So the judge in this case found that the husband didn't prove on a balance of probabilities that his wife had intended to gift him half of those assets. So the judge found that the assets remained the wife's. And in regards to the net family property calculation, it was still an excluded asset. It was just that the asset was a little bit less than when she had originally received the inheritance.
Exactly. So what can decisions like this tell us about how to assist clients with their estate planning? Clients who receive inheritances and maybe want to protect those inheritances from attacks by a spouse in the event of a breakdown of the relationship. Well, we might want to avoid any scenario where it can be alleged that there's a commingling of funds. Maybe we should be considering whether there's a way to open a separate bank account to hold this inheritance. As I mentioned before, when I'm dealing with family law issues, I like to call up a family lawyer and make sure that what we're doing is being done in a way that's actually protecting the asset from possible claims like that. And when we're using joint accounts, we want to remember that there are certain presumptions of resulting trust that might apply or may not apply. We want to make sure that we've got clear evidence of what's actually being intended by the spouses.
Yeah, I think going off what you said there, this case is a great example and a great reminder for all solicitors to be taking as many notes as possible and be asking as many questions as possible to determine for assets like this what the actual intent is behind it. And if you ask those questions and figure out what the parties are intending to do with the assets, then it's only going to help both yourself and the parties out in the future.
Absolutely. So I think this concludes our podcast, Darien. Until next time, we want to thank you for listening. I'm Nick Esterbauer.
And I'm Darien Murray.
Should you have any questions, please email us at info@hullandhull.com or contact us through the contact page of our website. Thank you.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.